Nicole Arundel from MFY to present a very in-depth review and nuts and bolts kind of a training, which we try to focus on for folks really falling victim to these foreclosure rescue scams. As many of you probably remember, back in December, the New York Attorney General's office put out or launched this web-based app for scams. And it's, in case you don't recall, it's agscamhelp.com. And it's a place where you can report issues, find a person who can help with your foreclosure prevention needs, and just general information about these things. But this really is meant for folks advocating for homeowners and trying to help get them out of a pretty crappy situation. So with nothing further, we will take questions during the presentation, and I'll leave it to Jennifer and Nicole. Thank you.
Thank you so much to both Michelle and Becky, and good afternoon, everyone. My name is Nicole Arundel. Again, as was mentioned, I'm a staff attorney with MFY Legal Services in New York City, and I'm here with my co-presenter.
Hi, I'm Jenny Eisenberg. I'm a staff attorney also in foreclosure prevention at South Brooklyn Legal Services.
Great. So we're just going to go ahead and get started in talking about advocating for victims of foreclosure rescue scams. Both Jenny and myself have done affirmative litigation in this space, and so throughout the presentation we'll be able to offer some real-world examples of our practice in this particular area. All right. So let's talk a little bit about what we are dealing with. Again, the foreclosure rescue scams are a national problem. These are just some of the headlines we've seen across the U.S., where we are seeing government and law enforcement stepping up and passing legislation, and in some cases actually enforcing the law in many jurisdictions against foreclosure rescue scam operators. We've seen attorney generals in various states start to go after the New York, particularly here in New York, going after loan modification scam firms, and federal judges issuing arrest warrants in some instances. So what we're going to talk about today is just, how can we, charge you guys as advocates to do more of these cases. I think both Jenny and I, in this practice, have had very little case law or anything to draw from. So it'd be really great to see more advocates stepping up and doing some of this type of litigation. So how did we get here? How did we actually get to this problem? Well, after the economic crisis in 2008, we know that the number of foreclosures rose across the country, and this created a market for foreclosure rescue scams. We started to see companies and individuals start to offer fraudulent loan modifications or other mortgage relief assistance, and they targeted those same vulnerable homeowners that they targeted with the predatory loan schemes. And now they come back and target those same individuals with schemes that talk about how to save their homes. And these homeowners who are desperate to save their homes many times turn to these companies because they're advertising guaranteed, fast loan modifications or other mortgage relief assistance. And when you're in a desperate situation, those types of options may seem viable. In 2014, the Loan Modification Scam Network, which is a part of the Lawyers Committee on Civil Rights, they found that they had received more than 40,000 complaints from homeowners that fell victim to foreclosure rescue scams. And this, if that number isn't startling enough, this totals to $90 million in losses for homeowners. That's a $90 million problem we're dealing with when we're talking about foreclosure rescue scams. So what we have here, it's in Spanish, but this also speaks to how some of these companies target folks. Particularly here in the New York City area, we've seen foreclosure rescue scam mills send out letters in Spanish to Spanish-speaking homeowners with things in the letters that seem pretty attractive. This letter here on the slide is from a law firm, and it was sent unsolicited to a homeowner in foreclosure by U.S. mail. They point out to her that she's in foreclosure, and by the way, she knew that already. She had been to several settlement conferences. They scoured the public records, and they inform her that she has a case on in Queens Supreme Court. Again, she was pretty aware of this. The law firm conveniently has a fraud investigation unit, and this fraud investigation unit discovered some irregularities in her foreclosure process. And for some reason, the same law firm has not yet discovered that they might be a potential fraudulent organization. And then this very busy firm is so busy taking money all day that they never, that you can't just drop by. You have to have an appointment only. So they let the homeowner know, by appointment only, you can come in and meet with them to find out more details. So what this shows is that the foreclosure rescue scammers across the country, and particularly what we've found in New York City, are using affinity marketing tactics. They try to build trust and put up a veil of legitimacy by using things like the same language or using terms that someone might have heard in the news media, particularly as you can see in this next example. This unsolicited letter was an attempt to look official. It includes a foreclosure case index number. It has a message of urgency. Look at all those exclamation marks. It also talks about MERS, because this particular scammer hopes that the homeowner actually read something or heard something about something called MERS, dealing with foreclosures. And this scammer claims that they can obtain reductions in principal and interest rate and ultimately suspend the foreclosure process. So as you can see, the solicitation itself, it looks official, has exclamation marks, includes lots of bold lettering. This is what folks are using to lure people into some of the common scams we've seen. So let's talk about what some, oh, sorry. Go ahead.
I'm sorry to interrupt. Can you put this in full screen mode, presentation mode, so that we can see? If you go to
Sure,
the bottom,
sorry.
That's okay. I was trying to see all the exclamation points you were referencing.
Sorry about that, folks. Hopefully you can see that much better now.
Perfect, thank you.
Okay. So some of the common types of scams we've seen are loan modification and refinancing scams, where people are guaranteeing to obtain a loan modification in some certain time period, usually something that indicates to the homeowner that it's faster than what they've been able to do on their own, or with a home ownership counselor. The scammer also may claim to have contacts in the bank that can speed up the process. So if you Google the term certified forensic loan auditors, you'll find this next common example where the scammer claims to have an attorney or some sort of expert on staff that can identify errors in the homeowner's mortgage documents. And those errors will be used to compel the bank to give the homeowner a loan modification or stop the foreclosure. And again, if you Google certified forensic loan auditors, perhaps there are some legitimate people that are certified forensic loan auditors. We haven't figured out exactly what that is, but there's also a school for obtaining a certificate to become a certified forensic loan auditor. So this is big business in all aspects, and this is not even exhaustive. Let's see a few other examples here. The sham foreclosure representation or sham lawsuit scam is when the scammer claims that they are attorneys or they represent a law firm. They promise to handle the homeowner's foreclosure case, or they promise to file a lawsuit against a lender or servicer. And that particular lawsuit will result in a loan modification for the homeowner or some sort of additional compensation. We've also seen the rent-to-buy or equity stripping scams, where the scammer requires the homeowner to surrender ownership of their home by usually signing over the deed and title. The scammer will tell the homeowner that, hey, I will clean up your credit, and you can, that you'll have time to clean up your credit by doing this, and then you can buy the house back from us later. Or the foreclosure go ahead and commences, and the homeowner is liable for the unpaid mortgage because he only transferred the deed, which does not impact what's owed on the mortgage. Some of the common tactics that the scammers are using, one that's definitely one we've seen in all types of instances, is the advance fees, which is illegal in New York. Charging an upfront fee before any work is completed, and in some instances before they even know whether or not the person is actually on the note to the mortgage. Some scammers disguise the fee as a retainer, and we'll talk a bit about how some of the scammers are using attorneys in these schemes. And we've also seen a common tactic used that there's a guarantee. The scammers will offer money-back guarantees or some sort of guarantee that they will obtain mortgage relief assistance, usually within weeks of the homeowner signing some sort of agreement to obtain services. And then this one is a good one, a common tactic we've seen, where the scammer will ask the homeowner to stop communicating with the bank. That means stop making payments, stop answering their phone calls, do not communicate with the bank. Because if you communicate with the bank, this is going to, impede our progress, impede the scammer's progress working on your behalf. So in one instance, I actually saw a contract that had on it, it said, in quotations, any communication with the client's bank is at client's own risk. Now, why would that be so dangerous? But I'm sure that would scare a few homeowners into not communicating with their particular lender. And that leads into this other common tactic, of course, where there's delinquency on mortgage payments. The scammer will advise that homeowner to fall behind on the mortgage payments so that they have a better chance of getting a loan modification or some other mortgage assistance relief. And I know I've actually seen instances where homeowners have told us that maybe the bank told them that. So I don't know if that's just common for scammers. We've also seen many instances of oral agreements where the scammer will describe the terms of the contract orally, usually in the language of that homeowner. So for us here in New York City, we see the scammers promising things orally in Spanish, in Mandarin, but then requiring a homeowner to sign a document that contains different or less favorable terms, and that contract is written in English. Again, we'll start getting into some of the laws around this, but that's illegal in the state of New York. The contract that's negotiated, whether that's oral or written, it has to be in that language of the homeowner. You can have an English contract, but you need to have a translation so that that homeowner understands the terms. So what this is about is us identifying, what's legitimate, what are the businesses that are actually offering real services, and we'll talk a little bit more on ways to figure that out. But now what we'll move into is discussing some of the legal theories that are used in these types of cases. This is not comprehensive, but we'll talk a bit about the common law and some of the New York statutes that Jenny and I have used in our affirmative litigation cases. Jenny?
Okay. Hi, everyone. It's Jenny. So starting out, and again, this is not an exhaustive list, and to some degree, we sort of tried to make this list with an eye towards creativity on the model that, the scammers that we've encountered so far, as scammy as they are, they're also really creative, and they keep coming up with sort of ingenious ways of abusing and defrauding and otherwise deceiving our clients. And so we as advocates really need to try to be equally creative in our ways of, of responding to those, to their ingenuity with our own. So here are a few of the common law claims that we have, that we've been working with. And again, not exhaustive, but here are some examples. We've thought about breach of contract claims, breach of fiduciary duty claims, fraud, obviously, that's a big one. Going along with that, conspiracy to commit fraud, a nice way of amplifying your claims. And also we've brought legal malpractice claims. So starting off with breach of contract, one thing to keep in mind is you're not always going to see a contract in the way that we're used to looking at contracts. And so, it might feel like what's happening to your client is a breach of contract, but it doesn't necessarily mean you want to bring a claim because, as I said, you know, these contracts could be very casual. They may not be written. So you really do want to kind of take a look at the elements of these claims and think carefully about what facts you have in your case. But okay, so breach of contract is applicable to cases where a purchaser and a seller are entering into a contract, and then the purchaser, the bad guy, subsequently reneges on some aspect of their agreement. And the elements, and you know, this is straight out of law school, existence of a contract, your client's performance pursuant to the contract, the defendant's breach of one or more of their contractual obligations, and then, of course, damages. So that's what you would be looking for in your typical common law breach of contract claim. Going forward, our next, sorry, our computer seems to have froze. Just one quick second here. Breach of fiduciary duty. So this is kind of an interesting claim and one that is not going to be universally applicable, but one of the things that we've seen in a lot of these scam situations is the sort of developing and then exploiting of a relationship between a scammer and our clients. In other words, the kind of solicitation and opening up of trust from our clients, and then developing a relationship over a period of time, and then preying upon the trust that arises from that relationship as a way of defrauding our clients. In situations where you see a really substantial and ongoing relationship between a purchaser and a seller, in other words, between one of these scam artists and your client, it really might be worth it to consider a breach of fiduciary duty. Obviously, fiduciary duties don't arise in every relationship, right? But they do arise in situations where you might be able to show a more protracted relationship. So it's definitely something to keep in mind. You know, it's a more unusual claim. On the other hand, it's a good claim for storytelling purposes because it really paints a picture of the betrayals that we see with a lot of these scammers. The elements of a breach of fiduciary duty claim are, you know, the existence of that relationship, and then misconduct by the defendant, and then again, damages caused directly by the defendant's misconduct. Okay, so this is a big one. Fraud. Basically, any scam that you're going to see is going to involve some kind of fraud, some stripe of it, because basically what we're talking about here is misrepresentation at its core. If there's one thing that all of these very creative scammers have in common, it is that they are lying in one shape or another to our clients. The important thing to note if you're going to be pleading a fraud claim is the requirement under the CPLR, and that's 3016B, that you actually include substantial amounts of detail when you're pleading that claim. So you do need to provide a more detailed recitation of facts than you would ordinarily do in your typical claim in a complaint. And you really want to make sure that speaks to the development of your case, the adequacy of your factual investigation, and you want to make sure that before you're pleading a fraud claim that you actually do it right, because again, you know, this is going to be the meat of your common law claims, most likely. The elements of fraud are misrepresentation of a material fact, and so in our scam cases, this is always going to be what's material is probably our clients want to save their houses. So if somebody's telling our client that they can save their house when they're not really planning on doing it, then that's a pretty easy misrepresentation to identify. Falsity, scienter, reliance, and injury. So typical elements of fraud, but again, very easily applicable to many, many scams. Sort of as a way, as I said earlier, of amplifying a fraud claim is the conspiracy claim. So conspiracy doesn't stand on its own as a common law claim, and so you do have to have the underlying substantive claim as well. But the reason why this is a great kind of add-on claim is because, A, these scam artists work in teams. These are not, for the most part, lone wolf scammers. They kind of can't be because it requires a lot of different players to kind of accomplish the sort of complicated scams that people are perpetrating. And again, you know, similar to the breach of fiduciary duty, conspiracy is a great kind of storytelling claim. You know, when you hear conspiracy, you think of a group of bad guys in a room doing something bad to your client. And so to the extent that you can paint a picture of a group of people acting together to take advantage of your client, it's really worth it to try and plead that out in a complaint. Obviously, with conspiracy, you do need to be able to depict a collective intent and that a collective unlawful intent, and so you want to make sure that whoever you're pinning with that conspiracy is somebody whose actions can be depicted as unlawful. And then finally, under common law claims, we have legal malpractice. And as Nicole said earlier, you know, in some ways, one of the more pernicious things that we've seen with these scammers is that they're getting attorneys involved to legitimize the businesses that they're doing. In other words, you know, we're seeing lawyers kind of step into these scams at various points and for various purposes, but, you know, to give the sort of veneer of legitimacy or trustworthiness to what is otherwise a wholly untrustworthy enterprise. I filed a legal malpractice claim against an attorney in my particular case who basically showed up at a closing, at a fraudulent closing, and introduced himself to my client and said, "Hi, nice to meet you. I'm your lawyer. Sign these papers." You know, I think all of us as attorneys and non-attorneys would recognize that that's not really what we picture when we think about having legal representation to protect our interests. And so it's a good claim to keep in mind. If you see an attorney playing really any role in these situations, interrogate what they are doing and who brought them there, who's paying them, and ultimately what kind of interactions they had with your client. Because chances are, if your client didn't seek them out, or if they just showed up at the last minute, or if they just put their signature on some documents, they are not acting in the way that you know, a member of the bar would be expected to act. Elements of legal malpractice, you know, the attorney failed to exercise ordinary skill and knowledge commonly possessed by a member of the legal profession, and that the breach of this duty proximately caused actual and ascertainable damages to your client. So, you know, again, if an attorney's passing documents to your client to sign and your client is deferring to them because they're trustworthy, that's a great example of, I would not have signed that document if somebody purporting to be my lawyer had not told me to do so. So that's just kind of a summary of some of the common law claims that we thought might be helpful to you all in developing your cases. We're now going to transition into the two. There are lots and lots of statutes that we can use to target these scammers. Nicole and I have each kind of used one big one in our own affirmative cases. And what we've both found is that they seem to be woefully underused, or at least to the extent that our research has uncovered it. And so I'm going to talk a little bit about RPL 265A, which is also known as the Home Equity Theft Prevention Act, also known as HETPA. So I'm just going to call it HETPA. And then Nicole is going to talk about the Distressed Property Consultants Act, which is 265B under RPL. So this is a monster statute. I encourage all of you to read it. We included it in the outline, and though it is not often fascinating to read a statute, this particular statute was drafted with a lot of input from advocates such as ourselves, and so I guess what I mean to say is that it's coming from a good place. There's a lot of great language, sort of just intent language and otherwise, and I think if we could, as advocates around the state, start using this more aggressively, we might actually really get some relief for our clients. What does HEPA do? So it does basically three things. It governs certain kinds of sales of distressed properties, so in other words, homes in default or in actual foreclosure. Number two, it regulates the form, the procedure, and the content of the transactions that are covered. In other words, it says how are these transactions going to look if they're legal. And then three is that it creates a whole set of remedies that your client can seek in the event of the statute being violated. What was the rationale for this statute? Well, it was passed back in 2006, and like I said, with a lot of assistance from people kind of on our side of things who are concerned about homeowner protection. It targets foreclosure rescue scammers who prey upon homeowners who are either in default or who are actually in foreclosure proceedings. One of the really important aspects of the statute is that it codifies a recognition that homeowners in distress are, and this is a direct quote from the statute, are vulnerable to fraud, deception, and unfair dealing by home equity purchasers. The statute also aims to preserve and guard the precious asset of home equity and the social as well as the economic value of home ownership. So this really is talking about home equity as its own commodity. And that in and of itself is kind of an important recognition. So, and then the statute also expresses concern about the impact of equity purchasers on communities throughout New York State. So it's a pretty ambitious statute, which is maybe the reason why people have not decided to use it so much, because it is kind of big and cumbersome, and yeah, and it's new. So there are a couple of terms of art that are commonly used throughout the statute. And as I said, you know, the concept of what I kind of describe as an equity-based transaction is really at the heart of the statute. So it's regulating the selling and purchasing of home equity. In other words, the sweat that your clients have put into paying for their house over the years, even if in and of itself that's not a liquid asset. So here are some key terms just to look out for so you don't get confused if you're trying to use the statute. Covered contract, equity seller, equity purchaser, and reconveyance arrangement. Wordy, very wordy terms there. What's a covered contract? So covered contract is basically, this is what's covered by the statute. Any contract, any agreement or arrangement, or any term thereof between an equity purchaser and an equity seller, which does one of two things, is either incident to the sale of a residence in foreclosure, or is incident to the sale of a residence in foreclosure or default, where such contract, agreement, or arrangement includes a reconveyance arrangement. Reconveyance arrangement is also known as a buyback agreement. So what this means is that both outright sales of property and also these more complicated buyback agreements are covered under HEPA. Really important because that ends up covering a huge range of transactions concerning distressed properties. What is an equity purchaser? These are the bad guys. So these are the individuals and the companies and the shady pop-up LLCs and other sort of random corporate entities that seem to be a little fly-by-night that HEPA seeks to regulate. They're going to come up in all forms. In my particular case, I've noticed that the same players are popping up in a subsequent case, and they've found another LLC name to use, but it's all the same guys. So, keep an eye out. Don't assume that just because something has an LLC attached to it that it has any legitimacy whatsoever. But that's what, so that an equity purchaser is your bad guy. It is any person or their representative who acquires title to any residence in foreclosure or, where applicable, default. These are investors and business people. These are not individual home buyers who are trying to just get a cheap property and live in it as their primary residence. So you see I list some exceptions here, and this is how you know who doesn't count. People who are legitimately buying property through judicial foreclosure sale, people who are buying property from family, people who are going to live in the property, a nonprofit organization that might buy the property. This is not who's covered by the statute. The statute is looking for shady people looking to make money off of vulnerable, distressed homeowners. Equity seller, okay, that is a vulnerable, distressed homeowner. This is who HEPA is trying to protect. And here you can see there's a difference in definition. It's a natural person who is a property owner or homeowner at the time of an equity sale. One really important thing to keep in mind here is that equity seller, I think the term kind of implies a level of agency or intent. In other words, that your client might have planned or intended to be selling the equity in their home. That's not always true. And so you should keep in mind that a person can be an equity seller even if they had no idea that they were selling anything or no intent to sell anything. The term is more to denote their position relative to their property and to the buyer. And then finally, with reconveyance arrangement, so this is a buyback agreement. And basically it's a transaction in which your client, the equity seller, is conveying title. And then there's a subsequent, usually it's a promise. It may be once in a blue moon there is an actual reconveyance. But generally speaking, it's a promise to sell back the property to your client, to the seller. And this is kind of like the core of what HEPA is trying to regulate. It doesn't outlaw these arrangements completely, but I think it's safe to say the statute kind of hates them, and that's why they're trying to make them very difficult to transact legally. Reconveyance arrangements can take a lot of different forms. And so when a client comes to you and it looks like they've lost title to their property, that's one way. In some ways, that's the easiest way. Your client actually signed over the deed. That's what happened in my case. My client came in still living in his family house. We looked up in ACRIS to see what had happened with respect to title, and surprise, he's no longer the owner. In fact, it's one of these LLCs that now owns his property. So sometimes it's as clear as that. Sometimes your client might sign a mortgage agreement with the buyer, so they haven't actually deeded the property, but they've done something, just a step below. Sometimes these guys create a lien against the property, which is especially sneaky because they generally are not letting your client know that they've put a lien on the property beforehand. Sometimes a buyer will give an oral promise to buy back the property. Sometimes there's an actual written document, rare, but I have seen it, where they're agreeing that the property will get purchased back. And then sometimes the buyer will give the homeowner a lease as if they're renting their own property until they can buy it back. So all of these things can really be defined as buyback arrangements, and you want to just look when a client's coming to you with something like this and see what is actually being promised and what is documented or not. What's wrong with a reconveyance arrangement? Well, they're basically like a terrible idea for your client. because if you think about it, an equity purchaser is only going to profit from this transaction if the homeowner can't buy back their property. If they can buy back their property, then what has the purchaser gotten out of it? Probably not much. So there's very little incentive for these kind of arrangements to actually help a homeowner to reclaim their distressed property. The goal is pretty much always for an equity purchaser to get a cheap property, and what do you think they're going to do with it? They're probably going to flip it for a profit. Because of the incentive structure here, it's pretty much a guarantee that whatever buyback terms are articulated, assuming that they are articulated, those terms are going to be really unfavorable to your client. But what's so crappy about these kind of arrangements is that it's deceiving homeowners into thinking that, oh, this complicated arrangement is going to be the way that you can save your home. So they're terrible. So one of the things that HOPP does is kind of recognizing how dangerous these transactions are and recognizing the many, many places where fraud is likely. HOPP regulates these contracts very carefully. You have a right to a complete contract, which is really important given that a lot of times these transactions are extrajudicial. They're happening not in the context of a court proceeding, and they're often the result of just kind of verbal, just conversations. Really important, these contracts must be in writing. So in my case, for example, I have the world's easiest violation of HOPP because my client's transaction was not in writing. The only thing that was in writing is his signature deeding his property over to the defendant. Contracts really have to have all relevant terms. So obvious stuff, basic information about the parties, the property, the payments being exchanged, any services being exchanged. Really, really important in these reconveyance agreements, the contract must state when physical possession of the property will be transferred to the equity purchaser and when a homeowner must vacate the premises. That's really important because one of the main things that's happened in my case is that due to the existence of this buyback arrangement with my client and the defendant, there is now an eviction proceeding happening in housing court. And there was nothing ever written about when my client would need to vacate the premises or when this developer could, acquire actual possession. So these are things that it's obviously incredibly momentous if your client is going to be physically ousted from the property. So the contract absolutely must dictate when, if and when that is going to happen and how it will happen. Obviously, any terms of any rental or lease or any other kind of buyback terms need to be articulated as well. And then finally, something called a cancellation notice, which we see in other, in other areas in this practice. But basically, cancellation, you have a right to cancel, just like as I said, in other areas of foreclosure practice. And your notice of cancellation, you've got to get 2 copies. It has to follow pretty much what the statute says as far as the right to cancel. You've got 5 days to cancel the transaction. This is your right to change your mind. And so you've got a little chunk of time, even after you make this decision, to completely reverse it. And you have to convey notice in writing. You can do it personally, via mail, via fax. And then the buyer has 10 days to basically respect your cancellation. And in so doing, they have to return the contract and any fees you paid and any other consideration. What's really important about that cancellation period is the cooling off period of 5 days. During that time, when we are hoping that maybe our clients would have gotten a second opinion or gotten some advice or reflected or otherwise kind of investigated their decision, we're hoping that the statute is saying that equity purchasers are not allowed to to engage in any conduct that would undermine a seller's exercise of their cancellation rights. So that would, for example, include, you know, kind of tacit or overt pressure to the seller to pay them any money, to not cancel, talking to them about how this is a stupid right and why would they want to change their mind because they just engaged in a fantastic and wonderful transaction. And then also really practical things like recording the deed before the cancellation period is over. So things you might want to do are look at the date of recording of the deed and look at the date of the transaction and see if that happened within 5 days. Because if it did, then you know that your client did not have a meaningful cancellation period to reflect on whether they wanted to go through with this. When it comes to negotiation of these contracts under HEPA, and these are probably, this slide and the next are probably the most important and kind of the meatiest aspects of the statute, just because they list a whole bunch of places where most likely these scammers are breaking the law. So our clients have a right to full disclosure of basically every term of the contract. So 265A sub 7 sub B articulates all of the different ways that this can play out. An equity purchaser can make no misleading statements regarding the value of the property, any proceeds the equity seller is going to receive, the timing of the judicial foreclosure process, any other contract term, the equity seller's rights or obligations under the transaction, the nature of any document that the equity purchaser is getting the seller to sign, or literally any other aspect of the sale of the residence or the buyback arrangement. So they just can't pretend that your home is worth something other than it is, or that the judicial foreclosure process is going to be commenced and finished in a period of time that it isn't, for example, or you know that a sale is imminent, or that the seller is going to receive a whole bunch of money, or that the seller is not going to have to leave their house if in fact they do. All of these come under the right of full disclosure, and there cannot be misrepresentations to that effect. The other sort of biggie under the negotiation of contracts piece here in HEPA is your right to an honest buyer. So this is kind of hilarious because basically the presumption is that equity purchasers are almost never being honest with our clients. But that being said, you do have a theoretical right to an honest buyer under 265A7, and then there's a whole bunch of subsections here. So the big thing here is that an equity purchaser can't obscure what their motives or their relationships are. They can't pretend that they're acting as an advisor to your client or a consultant to your client, that they're acting as their agent or on behalf of them in any way. So we see this crop up, for example, in my particular case, our defendants worked for an outfit called Homeowner Assistance Services of New York, which is pretty much the most tremendous misrepresentation you could make. And then better yet is they said that they would act on behalf of my client in talking and negotiating with Wells Fargo. So that right there is a tremendous violation of the statute. They're not our client's agents. When they're negotiating with the bank, they're not doing so on our client's behalf. They're doing so on their own behalf. So they can't represent otherwise. Also, these purchasers can't pretend that they have some kind of certificates or licenses that they don't really have, or sort of obscure the fact that they are actually licensed brokers or attorneys or whatever. They can't pretend that they're somebody they're not. Really important, they can't promise or insinuate in any way that they are assisting your client to save their house without having a good faith basis for doing so. And they can't pretend that they're helping your client to avoid foreclosure without a good faith basis for thinking so, or for saying so. Going along with this, I mean, just in case those provisions were not thorough enough, HEPA also kind of has a catch-all provision that says, in case you have really bad conduct that doesn't fall under all of those other statutes, you also are not allowed to engage in any other kind of unconscionable behavior. So any other really unfair terms, this is like your place to be creative. So if you're seeing bad activity that doesn't really fall under those other provisions, see if you can sort of shoehorn it into this last one. As I said before, so reconveyance arrangements, this is the buyback agreement stuff. HEPA considers these to basically be mortgages. And so then going along with that, it articulates a whole set of guidelines that have to be followed when you're entering into a buyback arrangement. There are a number of requirements that a reconveyance arrangement kind of has to follow in order to pass muster under HEPA. I'm going to go through these pretty quickly, partly because of time and partly because it is incredibly complicated. And the most important thing that you want to just keep in mind here is once you see that a transaction that your client is coming in with looks something like a buyback agreement, then you really want to take note of the provisions of HEPA that deal with what these arrangements can and cannot do, because chances are it will violate the statute. One major thing, though, to keep in mind is that these buyback agreements absolutely must be recorded, and they have to be recorded with the deed. And so that's in terms of the beginning stages of your investigation. If someone's coming in and saying they have a buyback arrangement and it hasn't been recorded, then you know right there that's a big violation. Finally, so this is the fun part, what are your remedies under HEPA? So here are the remedies. You can rescind a transaction that's covered by HEPA within 2 years of the transaction. You can file a lawsuit, and it codifies a 6-year statute of limitations, which is actually like fairly generous in comparison to lots of other statutes of limitations. HEPA actually involves, it also includes criminal penalties, which is interesting and unusual. And then there's also a provision for independent enforcement by the Attorney General. So rescission, we should say we supplied a sample rescission notice, and this actually gets recorded. You know, it becomes a matter of public record. And basically, even if you didn't use your cancellation rights, you can still rescind the transaction by serving notice on the purchaser, recording it, and then the purchaser has 20 days to reconvey the property and return any consideration. We have no idea if this has ever worked. I've filed 2 rescission notices, and I would note that those transactions have not been rescinded. But on the flip side, it's helpful to do because then when the purchaser does not actually undo the transaction, then you can include a claim for enforcement of rescission in your lawsuit, and you can collect costs and fees. Obviously, the most powerful remedy is filing a lawsuit. So you have 6 years to do it. The provisions you're looking at for identifying your specific claims are under 3, 4, 6, 7, and 11 of the statute. The damages you can get are both actual damages plus fees and costs and equitable relief, and a judge could even triple your damages. So there's a lot of different stuff you could get. You could get damages if your client has lost rent, or you know, presumably you can get emotional distress. You could get the house back, and then this could, you know, go as far as to triple. So it actually seems like a pretty rich area. Criminal penalties, kind of interesting. Again, we don't have any idea if this has ever been used, but might be interesting to try and initiate this process. An equity purchaser who commits a knowing violation of HEPA could be prosecuted for a Class A misdemeanor, which has up to a year in jail attached as a potential penalty. If you violate HEPA with an intent to defraud, which it seems to me like you can't really violate HEPA without an intent to defraud, you could be prosecuted for a Class E felony. And even 2 misdemeanors could bump up to a felony, and so this is obviously aimed at repeat offenders, and it would be hard to find a scammer who isn't a repeat offender. They kind of perfect their scams by doing them over and over and over again. So especially maybe in some of the less busy district attorney's offices, it might be kind of interesting to get your local DAs involved and see if they'd like to prosecute some of these guys, because I would not be surprised if outside of the major metropolitan areas, if you might actually get some traction there. And then finally, there's a provision for the Attorney General's office to independently enforce violations of HEPA. And obviously the Attorney General has plenty of powers at their own disposal, including injunctive relief. They can seek civil penalties against these scammers. They can subpoena their records and find out just how scammy they are, and then ultimately make findings of fact. So there's a lot of different things that HEPA can do. My particular lawsuit hasn't proceeded yet to remedies. I'll be interested to see what happens, but I certainly am crossing my own fingers. So I think that's about it for HEPA, and now we're going to move on to 265B and back to Nicole. Oh, but before we do that, if anyone has questions, I can try to answer. I don't know if we want to do that now. But, okay.
Yeah, I think right now we only have one, and it has to do with essentially the first part where you started to identify the malpractice issues and ethical issues. So one gentleman asked, I've always thought that it was a violation of the ethics rules to make an unsolicited letter, an ambulance chasing, by seeking out lists of people in trouble.
Yeah, it is, and attorneys can't solicit business. That's absolutely true. On the other hand, what we've seen happening a lot is that it's very easy to get lists of, who's in active foreclosure, and I think even before that, it's very easy to find out who's in default. And so these outfits can send letters, and as long as they're not, I think in Nicole's case, the first Spanish letter is just very clearly in violation of that. I think some outfits think they're getting around it by not necessarily purporting to be from a law firm per se.
Right. Yeah, I think that's true.
Okay. But yes, it is a violation. They are not supposed to chase ambulances.
So put that into your complaint too.
Yep.
Okay. And so now the other big statute is the New York Real Property Law 265B, which is also known as.
Can I just ask one more question? It has to do with A.
Sure.
Okay. So
sorry.
Under 265A, it defines foreclosure to include a property, quote, on an active property tax lien sale list. Do you have any thoughts about how far along a tax default needs to be to meet the definition of a foreclosure necessary to be a covered contract incident to the sale of a residence in foreclosure, especially given that tax foreclosure process is often unique to the county? You might want to read that yourself too. It's a bit dense.
I am going to try and read it, but let me see here if I can. Okay. How far? All right. So the question is really how far along a tax default needs to be. I think, and again, I don't actually know how big the differences are from county to county. I think basically once you're in default, once there is a tax default, that's enough. And I think probably our overall kind of advice here in terms of what's the ambit of the statute and what's a defaulted property, we would probably encourage everyone to be broader and let the defendants come back and say that the property wasn't actually distressed. I mean, the whole point is that they're not they're not potentially profitable if they're not distressed. So I would define that pretty broadly. I don't think it needs to be an active foreclosure at all.
Okay. I think that answers the question. Thank you. Go ahead.
All right. Are there any other questions before we move on?
Nope. Go ahead.
All right. So the New York Real Property Law 265B, which is also known as the Distressed Property Consulting Act. It's one of New York's most significant consumer statutes that governs this foreclosure rescue scam actions. And under this particular statute, consumers have a private right of action to pursue litigation against the foreclosure rescue scammers. And courts can award restitution to the homeowners. They can impose civil penalties against the scammers for each violation of the statute. And the AG is empowered to enjoin and restrain violations of the statute provisions. So who is a distressed property consultant? Again, this particular session that we're doing is not about anyone who's legitimate or a legitimate business, individual, or law firm that's actually not breaking the law. This is about all the other people. So a distressed property consultant are individuals, corporations, partnerships, LLCs, business entities that directly or indirectly solicit or undertake employment to provide consulting services to a homeowner for compensation or promise of compensation with respect to a distressed home loan. So what that means is basically a person or a business that's helping people who are typically in foreclosure or close to losing their homes to foreclosure, and those who may be at having a potential loss of their home for non-payment of taxes. Our clients, essentially. A distressed property consultant in New York does not include attorneys admitted to practice in the state of New York when that attorney is directly providing consulting services to a homeowner in the course of his or her regular legal practice. And as we mentioned earlier, we haven't seen a lot of case law utilizing these statutes, but in a recent case, and in full disclosure, this is the case that I brought, Bardo versus American Hope Group in Supreme Court in Queens. Our motion in opposition to the defendant, fraudulent scammer person's motion to dismiss, was actually granted. And in that decision, which is published in the New York Law Journal, the judge noted that the attorney exemption in the statute only applies when an attorney is directly providing consulting services and not merely if the attorney is on staff. So as I mentioned earlier, you'll see some of these scammers, common tactics would be, we have attorneys that work with us. Well, is that attorney actually putting their hands on documents and doing the work to save your home? If not, then that's not good enough. It has to be directly, or even if it's indirect, there has to be some type of interaction with that homeowner. The distressed property consultants are also not lenders or banks or bona fide nonprofits like homeownership counselors, for instance. What are distressed property consulting services? All of the fabulous things that everyone on this phone call does. It's consulting services to stop, stay, void, or postpone foreclosures, obtain a forbearance, assist that homeowner getting reinstated, or a loan modification, or saving that homeowner's property from foreclosure or loss from non-payment of taxes. And what is included in a distressed property consulting contract? Well, under this statute, a distressed property consulting contract, it must be in writing. Again, scammers will talk and talk and talk on the phone, in person. They come to people's homes promising things, but that contract has to turn into something that's a written document signed by the homeowner and include key provisions such as the entire agreement of the parties. So things that may have been promised orally need to be put into writing. They must be provided in writing. It must also be in 12-point type. I mean, the statute actually says that. I can say that I've seen many of these contracts, and I don't know if they always fit that bill, but that would be a violation you could add to your complaint. They must be written in the same language that is used by the homeowner and was used in discussions between that distressed property consultant and the homeowner to describe the services or to negotiate the contract. So that's key. Many of the homeowners that I represent in these cases, their second language is English. They communicate with the scammer in their primary language. And many times, again, as I mentioned earlier, those contracts that they sign are not translated. They're not written in the language of the homeowner, and that would be a violation of the statute. Those contracts must also include the exact nature of services, the total amount of compensation. Many times I've seen homeowners who've entered these into these agreements. The scam company is promising to give them a loan modification and also represent them in a settlement conference. It may not include the total amount of money that this contract actually encompasses. For instance, they may pay for monthly fees to have that scammer work on their loan modification package. But then when they go to court, they'll show up in court and someone from that scammer company is asking for cash before they walk into a settlement conference. Many times those contracts don't mention that, oh, by the way, when you go to court for your settlement conference, you're going to have to pay myself or some other attorney who shows up $400 in the hallway before we go and represent you for 10 minutes during a settlement conference. The contract must also include a notice of right to cancel. And in New York, that's really important because homeowners do have 5 days to cancel this contract. And many times you'll see the contracts do not include the notice of right to cancel. Or if they do include it, they miss out that part about having 5 days. They may just say, you have a right to cancel this, but with no exact time frame. Some of the prohibitions under this statute for distressed property consultants. Distressed property consultants are prohibited from performing consulting services without a written contract. They're prohibited from charging upfront fees, which you will see everywhere. There's always some upfront fee before consulting services have commenced. That is a clear violation of the statute. They are also prohibited from taking a power of attorney from a homeowner, from retaining any original loan documents or other original documents related to that home loan. And they're also prohibited from inducing or attempting to induce a homeowner to enter into a consulting contract that does not fully comply with the provisions of the statute. Well, they ultimately violate that one pretty much every time. The remedies under this particular statute are great. The court can nullify any agreement between the consultant and the homeowner. And that homeowner can also recover their actual and consequential damages and costs as a result of their interactions with the distressed property consultant. And in instances where the court finds that that distressed property consultant intentionally or recklessly violated the statute, the court may award the homeowner treble damages, and that is fantastic. In my case, in which I brought under this statute, we're still proceeding with the case right now. We have not yet received a decision. We're still in discovery, as a matter of fact. But knowing that my clients have the potential to receive triple what they were damaged at this point is a great remedy. So some of the other legal remedies, or before we get there, are there any questions pertaining to RPL 265B that we can take quickly?
Nope, not right now.
All right. And some of the other legal remedies that we've used in our complaints or that you'll see in these types of cases include, particularly in New York City, there was an administrative code that was added, a provision added to the administrative code in New York City, which we know doesn't apply to you guys upstate, but there might be something similar in some of your cities where the cities are actually codifying the state rules. So you may want to look around and see if there's anything that does that. And in New York City, we found that there was actually a city administrative code that codifies pretty much the Distressed Property Consulting Act that the state has. So it provides that in New York City, if you're going to do this type of work, you have to have a written contract, you can't accept upfront fees, that sort of thing. So we included that just to say that, some cities are actually starting to codify what the state is doing. So be sure to check and see if your particular city has started to put that into its administrative code.
If I can add,
oh, sure. Go ahead.
I'm sorry. Can I just add, I have not heard of any upstate cities that have done that, but I am extraordinarily interested in hearing from folks if, in the process of doing your research, if you can post that on the Settlement Conference work group list or the upstate legal list, that would be fantastic. I'd like to hear if there are any other cities that have done that yet.
And yeah, and we found this has just happened in the last 5 years, like in the last 4 years maybe. So it's relatively new. And again, a lot of people just aren't really utilizing it. So if your cities are starting to codify this, it's a great tool to use because the city, at least in New York City, they included a provision where the city can impose civil penalties against that particular scammer per violation. We've also used the New York State General Business Law 349, which is Deceptive Acts and Practices. Again, this is a statute that's very broad and it can be very broadly construed, but again, these are consumer-oriented acts, and many times the scammers are doing things that are materially misleading that homeowner, and the homeowners suffer injury, foreclosure, credit damage, etc. So this is a good tool to use in these complaints because under GBL, the remedies there, the individual plaintiff may be awarded actual damages or $50, whichever is greater, but the court may also award treble damages for willful and knowing violations, which you will definitely see in these instances. I did not use this particular provision, but we know of other attorneys in New York that have used the banking law 590, which is a licensing and registration requirement. So in the state of New York, no individual or corporate entity may make a residential mortgage loan without being licensed to do so by the state banking superintendent. And they also can't broker, service, solicit, or negotiate such a loan without being registered to do so. So some attorneys have used this particular statute in the foreclosure rescue scam cases in instances where someone is negotiating that loan on behalf of a homeowner. And this particular, good to point out here that does it apply to lawyers? A lawyer is exempt from the requirements of this particular statute if their activity is incidental to the legal practice that they have. And here's a bit more information about banking law, another provision of the banking law 598 that provides that any person affected by activities not in compliance with the previous statute, 590, that they may recover by litigation up to 4 times the amount paid in connection with those activities. So again, these are just some other good tools to have on hand, and New York State really has some very consumer-friendly, homeowner-friendly types of statutes that we could be using to go after the scammers. So just some general information about developing an affirmative case in this particular space. And again, this could be applied to bringing affirmative cases of all types, but we plotted out some general basics on how we approached these particular bringing actions in the foreclosure rescue scam space. So these are early case assessment tips. Advocates must attempt to evaluate the foreclosure rescue scam with very little information. And by that I mean clients will walk into your office, you know that they may be close to foreclosure or in foreclosure, but then they'll also mention, by the way, I was working with this company that said they were going to get me a loan modification, or I was working with this company that, they told me to sign over the deed to my house to them, and now I'm getting notices that my house will be sold, and I thought I didn't have the house anymore. Just they'll start out with that as their story, but then may not have a lot of documents, may not remember the names of people that they interacted with from this particular company, all sorts of things. So when developing and deciding whether or not this is the kind of case you want to bring, we just highlight a few early case assessment topics here that we think are important. A lot of key information that your client may not know might be available from publicly accessible resources. And by that, I'm referring to things that you probably use all the time but haven't thought about it in terms of for your own bringing a case. So for me, I knew the name of the foreclosure rescue scam company. I knew names of maybe a few of the individuals that my clients interacted with, and I went from there. I used LinkedIn to see if I could find out more information about the company, perhaps find out how many employees that company has. I used the state corporation website to find out, is the company a registered corporation in the state of New York? Who are the principals? Where can you serve process on them? So starting to utilize those sorts of things. I Googled and found Facebook pages of employees of the scam company. I also went to use the Wayback Machine. If you guys are familiar with that particular website, you can Google it. It's the Wayback Machine, where you can type in the website of a company, the website address that they may have now, but you can also look back several years to see what their websites looked like in previous years. And that led me to a lot of different documents and information that the scam company used to post before, maybe they got found out about their illegitimate scheme and attempted to correct in their newer website. But I went back and downloaded all of that evidence to use in my case. So you really have to start thinking about what are publicly accessible resources, social media. There's a lot of ways that you could start to find out much more information about the scammers that maybe your clients, when walking in on first blush, don't necessarily have, and you just got to get really creative. And I have some other ideas on tools and things that you could use that I can email to folks offline, but in the interest of time, we'll move on. So again, you need to understand the facts of these cases. They're very tricky, and again, your client may or may not have all of the right facts, dates, and chronology, but that's going to be important in deciding whether or not you want to bring an affirmative case in this space. There aren't many cases that have been brought, so judges aren't very familiar with these statutes that we're talking about, or what really applies in these cases. They haven't seen this, so you need to lay it out for them. So that's why we're talking about some of the basics when bringing affirmative cases, but you really need to use these basics in bringing cases like this that just have not been before New York judges. That client interview, you need to get as much background information as you can. Understand what that client's objectives are. Many times the clients are just distressed. They want to keep their home. They're really not worried about going after some scam guy who they gave thousands of dollars to. I mean, I may want to, but the client may not have that as their objective. So understanding your client's objective, or should I just be focusing on providing legitimate foreclosure representation to this client instead of pursuing the particular scammer? Evaluate whether that client will be a good plaintiff for the case. In terms of my affirmative litigation case in this particular world, there were potential plaintiffs that I turned away, that I just said, you would not be a good plaintiff for this case because you do not have copies of documents, you do not know, or you do not have information that you signed, you don't have copies of payment stubs, things like that. Like, think about who would be a good plaintiff for a case where, again, judges haven't seen these. You need to have people who have, good information, who have their, story together, and perhaps if they don't have it together, they have enough information that you could piece together and paint the picture for the judge. Gather as much evidence as possible. Again, I mentioned some of the sites that I go to, such as old websites, flyers, business cards, job postings for the scam companies. You learn a lot about the companies that way. Looking at their Better Business Bureau complaints, which inevitably there's probably tons when it comes to some of these companies, and any other information regarding the scammers. Collect all of that, PDF it, have it on hand. Be sure to collect all of the documents and materials your client has that's relevant to the scam. And then that's when you get to start to organize the case around, like, what are the strengths, what are the weaknesses here, do I have a lot to go on, and that's at the beginning. And now after this training, you understand the law. You know all of the potential common law claims you could bring, what statutes are really your go-to statutes for the cases. So this part is easy. You can identify it as, once you've laid out all of your client's information, you now can kind of understand whether or not, looking at the elements of the statutes, hey, do I have, something that's good here? Let's organize this around strengths and weaknesses under these particular statutes. Identify what my potential claims might be, what some counterclaims would be, and cross claims. And, find a good intern to do some case law research. But again, you may not find too much because people aren't really, in New York, really bringing these cases. So hopefully we can get that changed sometime soon. And again, you're going to build a case plan, organize and link your case facts, the cast of bad actors, all of those scammy people your client has interacted with, and all of the documents that, organize your research and your issues. Review relationships between your facts, the issues, and research to identify case strengths and weaknesses, and confirm that you can prove or defend the issues within your case. I mean, these are tricky cases, so you really need to be able to have factual support or a good faith belief that you will obtain factual support as you progress. And this is how you start to develop an affirmative case, laying out these things. And so it seems very basic, and you probably do this for those of you who've brought affirmative cases, but I think it's important to go back to the basics on how to develop an affirmative case, because that's where you are with these types of claims. I know I've been before a judge in the state of New York who's looking at me funny when I'm talking about the real property 265B. It's like he looks puzzled, but so you really do have to lay it out for folks. So let's say you decide that the client, we really don't want to bring any cases, but we do want to do something to address the scammer. So some attorneys have used administrative complaints as a tool, going to the local district attorney's office, where you'll find an economic frauds bureau, and filing complaints there. Those DA offices obviously won't address any civil causes of action, but may pursue some sort of criminal investigation. As was mentioned earlier, the agscamhelp.com is a great place online. You're able to upload documents along with your complaint to the AG's office, and the AG may already be looking into that company that your clients have dealt with. So that's also another opportunity to file a complaint there. Just to note, the FTC, again, this doesn't have a private right of action, the Federal Trade Commission's statute in this space, but it's important to know that even on that federal level, so when you're filing a complaint with the Attorney General's office, they are able to use the Mortgage Assistance Relief Services Rule, also known as the MARS rule, and basically it bans those same things that New York is doing on a state level. It bans the advanced fees. It applies to real estate brokers and agents, mortgage lenders, et cetera, who are trying to do basically distressed property consulting services. Excuse me. And it also bans disclosures, or it includes that disclosures in advertising and in communications directed at customers, prohibits, pardon me, mortgage relief companies from making any false or misleading claims in their advertising. And that MARS rule also has an attorney exemption. The attorney must be engaged in the practice of law, must be licensed in the state where the consumer or that dwelling is located, and the attorney must be complying with state laws, i.e. RPL 265A and RPL 265B, et cetera. And that particular and those regulations must govern that attorney's conduct. So this is just so that you know that at that federal level, filing the administrative complaint, that Attorney General's office has the capacity to bring actions, particularly under the MARS rule and any other state rule we have as well. The CFPB, Consumer Financial Protection Bureau, has started to really examine the foreclosure rescue scam operations. And they're particularly interested in complaints where people are using government things. So you'll find sometimes the scammers will say, we've been approved by HAMP, and that might that might entice a homeowner because in the news I heard about a HAMP. I think I can get a HAMP, and they said that they're approved by HAMP. So CFPB, the Consumer Financial Protection Bureau, is particularly interested in those types of representations by scammers, and also the ones that are the scammers that are using law firms or working with lawyers in some capacity to do their claim. To perfect their fraudulent activity. And then finally, the Lawyers Committee for Civil Rights Under the Law, as I mentioned earlier, they have a loan modification scam network, which is a national complaint database. They've collected data from across the country on foreclosure rescue scams of all types. Their website is there. They have a capacity for you to also become a partner where you can have access to that database, so that might be helpful. Our organization, MFY Legal Services, became one of those partners, and I was able to use that database, the data collection for the scam companies that I sued, and find out some other, potential clients, or at least see how many other victims might have been impacted by that particular company. So it's a helpful tool, and they're a helpful resource. They've brought several cases in the state of New York against scammers in very large impact litigation cases. And this is just a little bit, when we've done this training previously, we've had a whole section on ethics and the ethics rules that surround this, but this is just in brief. Obviously, a lot of the scammers are starting to use attorneys in some way. Approximately 22% of the complaints that a coalition of government agencies, nonprofits, and service providers receive from consumers about loan modification fraud involve some form of attorney participation. And a lot of those complaints that the Lawyers Committee received in their loan mod scam network, 10,000 of them dealt in some instances with cases where attorneys were involved. So you just need to be mindful of that. But thinking back to particularly the decision that I received in Brardo versus American Hope Group, we're finding that judges are saying, hey, it's just not good enough to say you have some attorney hanging out in your office. Like, what is that attorney doing? Is that attorney working on that particular client's loan modification or foreclosure representation or whatever it is? You need to have more than just someone that's on staff or, affiliated. So that's just to point out that there's definitely some ethical issues that surround this, and I think we include, yes, we do, where to find some of the ethical rules that could be helpful to you. And then there's, for the New York State, there's a whole set of ethics opinions on the website there, nysba.org, ethics, and other ethics opinions. And none have really been necessarily very specific to foreclosure rescue scams, but they're particular to instances dealing with maybe a broker and a home that's in foreclosure. I think there might have been a couple on deed theft. So you'll see something that can be applicable to this space. And if you're interested in more on ethics, Jenny and I, again, we did have a section of this included in a previous training that we did, and we're happy to share with you more slides and written materials around ethics rules, should anybody want those. And that is that.
If anyone has any other questions, we're happy to take them. We tried to include a lot of materials
in the written materials, yeah.
Yeah, so hopefully that's pretty helpful. What we really wanted to do is just make this as helpful as possible for people to just take it and see if you can come up with a lawsuit and file it so that we can have more of these and not just us because we're lonely.
So this is great, and I have to say, just on a personal level, having been there when these statutes were created and being a part of that in some way, and then the idea, the intent of it was really these property flippers that came in, and to see these statutes now getting used with the newest, quote-unquote, newest form of scams is really fantastic to see how you were using it to plug other holes that developed over more recent years. So this was great and very helpful. At this point, the only comment or question we have right now is awesome presentation. So I think that's
Thank you very much. Thank you.
So this was great. Thank you both very much. And if other folks have any questions, the text box is still open. Otherwise, have a great rest of your week, and thank you all. And go sue some bad guys.
And feel free to email us if you want more information or need to just bounce ideas off of us. And I think Becky or Michelle can share our email addresses with folks.
Yeah, that's totally fine.
Absolutely, yes. All right. Thanks, everybody. Have a great week.
Okay, bye, everyone.
Great job.